It's time, America.
Good morning, everybody. I figured I'd just go live with a little news update here. Let me just bring that in. This is kind of from the true crime world, but more from the sports world, in case you're interested in this story. Um, so, pulling this up here. So, last night, Coach Sharon Moore was fired by the legendary program from the University of Michigan. And we didn't know why. It was for people that follow college football. It was a huge thing. His firing. This is a very big program. And then it turns out that he was jailed just hours after being fired. But according to the story, we don't know why. So he was booked into jail at 10:11 p.m. last night. The county record system reached by CNN Sports did not have any information on the charges that Moore may be facing. No bond information available, no scheduled court date. So this is probably connected to the reason he was fired. Something must have happened, and then so that Michigan knew that he was about to be arrested. Let's see. In response to a request for information about the incident involving Moore, Pittsfield Township Police sent a news release stating that officers had responded to the 3000 block of Ann Arbor Saline Road to investigate an alleged assault. Police confirmed that a suspect was taken into custody, and the incident does not appear to be random in nature. I don't know what that means. Was it planned, I guess? So it wasn't just like he was in a fighting gun. So he was, I guess that means he targeted somebody. At this point, if that was Sharon. At this time, the investigation is ongoing. Given the nature of the allegations, the need to maintain the integrity of the investigation and its current status, at this time, we are prohibited from releasing additional details. That came from the police. And the release does not specifically name more. So it just ESPN is connecting those dots, and CNN, it's not established that they are necessarily connected. So it would imply that he assaulted someone, could have been, and it was new, and that was the reason he. It could be Jane. I didn't want to say something like that out loud because you don't want to speculate. You can speculate in chat. I can't really speculate. I have to be a little more careful. Sorry, I just need a morning cough drop. I don't know if he was married, had a girlfriend, no idea. Could have been, could it have been? Yeah, I don't want to speculate. Again, sorry about the cough drop. It's in the morning. You guys know it can be difficult to talk. I'm sure some of you experience the same thing. Let me see if there's anything else going on in the world of CNN. U.S. seizure of oil tanker off the coast of Venezuela. The Trump administration's seizure of an oil tanker off the coast of Venezuela is one of the most yet in military pressure campaign against Venezuelan dictator Nicolas Maduro. I wonder if activity on that tanker. And that's what they're claiming, indeed. Early reports suggest that this action poses fewer legal and constitutional concerns than the sinking of the other boats. I'm going to stay with you and just kind of monitor chat for the moment until people get here. I can't quite talk yet. Nobel laureate says U.S. helped her to leave Venezuela as Trump escalates pressure. And she must be an activist, and she has vowed that her country will soon be democratic and free. So, Venezuela, when they elected Hugo Chavez a couple of decades ago, went away from democracy and turned towards the hard left, and it destroyed the country. This was a country that has huge reserves of oil, and it was so mismanaged that they now don't even really sell oil anymore, barely. And the people are starving. It's all been mismanaged by the leftist regimes here. Maduro was the one that followed Chavez when he died of cancer. Good morning, everybody. Just looking at chat. Barbara, Tolley, Griffey. Good morning, Barb. So today, in the Brian Walshe case, the defense begins, and we're expecting that at some point in this defense presentation that we'll hear from the defendant himself. He is expected to testify based on what was indicated by his own team in their opening statements. It's not a certainty, but it's expected. Certainly, they've created that expectation with the jury, too, and it does seem like he almost kind of has to. He's not required by law. He has a right to not testify, and the judge will tell the jury that. However, the fact that his own side has told the jury a story that Brian woke up to find him, it does seem that he's going to have to tell the jury that story himself, as was indicated. So will they go up first? Will Brian Walshe go first? We might see Brian Walshe testify this morning. I would say the odds are probably at least 50-50 that that's the case, that we will see Brian Walshe go up there and sell the world or sell that jury that particular wild story that he woke up and his extremely healthy and active wife of 39 years old was simply dead in bed next to him. Now, that's not impossible. People do die in their sleep if they have a heart defect or something like that that has never been found. However, why do you immediately react by deciding that the public or the police are going to think that you killed your wife, so therefore you have to dismember and dispose of her body? That has to be explained to a jury too, and that's going to be very difficult to explain. Griffey, so Margaret saw the defense list, and we don't know how many, but there are going to be some. Typically, there's going to be, but it does seem like they are going to offer some experts who will testify that medical experts who will testify that it is possible for someone to die in their sleep, even at that age, and and with all indications of Anna being healthy. Right, Valeska. He has a public defender, so they would have limited funds. Yeah, Ken says, is La Pasado their ME? Well, she's the kind that would testify for money if he could afford it. I shouldn't say that. I guess she might sue me. So let's just say that some lawyers are willing to do that. So let's not necessarily finger La Pasado. Good morning, Dawn Marie. So let's see if anything else is in the news. I could go to Fox News, but they run a lot of pop-up commercials continuously on there, so that would be annoying. Not sure if you guys have any suggestions where we should go for a news source to see what's going on. Actually, one area is just to let the Microsoft news, they kind of do a somewhat balanced view of it. Go to Microsoft. Yeah, we could try Reuters next. Let me try it. So when you're in Windows or Edge browser and you open a new tab, Microsoft will bring you headlines. So we'll just scan through these. I'm an old school person. I prefer to read, so I'm kind of annoyed that most of the news stories when you go to these things are videos, and then I have to watch a video because I can read faster. So I hate it when I click on something and I think that it's a written article and it turns out to be a video. All right, see this one up here. This is a video. I won't click on it, but this is the country that built 173,000 bunkers for a war that never came. Now, I'm not going to click on it, but I bet I know which country they're talking about. And I wonder if Tom Fleming does. Tom served in the military in Europe, but I believe Sweden did that. Cam Newton can't believe Phillip Rivers got the NFL comeback call before him. Oh, so Cam still wants to play in the NFL. I kind of like Cam. When he came to the Patriots, he wasn't very good, but I liked him. And I watch him on First Take, ESPN's First Take. And he does a good job. He's a very intelligent analyst, but I don't see anybody wanting him as a quarterback. But then again, you got a team like the Indianapolis Colts, who has now lost all of their quarterbacks. Their main quarterback, Daniel Jones, is out for the season, and they have a winning record, so they have a chance to make the playoffs. So they want to. So they're in the process of potentially calling Phillip Rivers out of retirement. He's been retired for 5 years. He's 44 years old. And Phillip is on the practice squad now with Indianapolis, and Cam wishes it was him. Margaret is almost here. She's setting up. We see her getting ready, and then typically she will send me a wave, and then when she waves, then I know she's ready. There it is.
Hi. Oh, I was going to head into court today, Kevin, and then I was so busy covering these trials. Good morning. And I looked at my little calendar, and I have a dermatology skin check at 10:45, so I'll have to do that quickly. I can't cancel it now, and then go into court. These doctors.
That's what I had Monday. That's what I had Monday. What I believe.
And it's one of those things. It's tough to get back in. You know what I mean? So I hope. I mean, I was gonna. So basically, I'll go from the skin check right to the Dedham courthouse, and that will be around. I'll be there probably around 11:30. So.
Have you got any indications since last night about what's going to happen today? Whether Brian's going to testify and what time?
No, I don't. I have no idea. But I was thinking about it. So there's two things. He's either going to take the stand and then end with the medical experts that he has saying that, yeah, you know what? His story is plausible. Okay. That she died suddenly. She had stress, lots of stress. And so she died suddenly in her sleep. Or they're going to put the medical experts on first. And then remember, he can decide whether he wants to testify or not all the way up until the end. Maybe the attorneys are saying, look,
Right.
Why don't we put our experts on and then you can decide? And if I'm an defense attorney in this case, I think that's what I would advise him. Like, just let's see how our case goes in and then you can decide.
And would that include watching the jury to see their reactions? See how closely they're paying attention, see if they're taking notes, things like that?
Sure. Absolutely. So, and I thought
Ken Weeks has a question you might want to take on.
Hi, Ken. Good morning. I'm still not up to date on this trial. If the jury doesn't convict on the premeditated charge, no. Okay. So let me explain the law there. It's actually kind of interesting for this state. Right now, all he has, Brian Walshe, all he has on his indictment or his charge is first-degree murder. Okay. The lesser includeds, which are second-degree murder and manslaughter, are not there. Okay. 0. So if the defense or the prosecution asks the judge to include them in her instructions and allow the jury to deliberate on the lesser includeds, then it's up to the judge to decide if there's enough supporting evidence. But right now, neither side has asked for those lesser includeds to be included. Okay. So the jury can't willy-nilly say, all right, we don't see first degree murder here. Let's hook him on manslaughter. Let's hook him on second degree. They don't have that option right now. Okay. So as we see it right now, it's first degree premeditated murder or nothing. But that can change if there's a request. But that's a really, really good question.
We've been trying to.
Oh, yep. Sorry, Kevin.
No, it's okay. We've been trying to, get that question down to the clearest answer possible all during this trial. So we've asked Margaret it many times. So
and that's the answer. Yeah.
Getting more succinct. And the other thing that I guess we talked about this yesterday too. So the state would have had the option if they chose to or would it have? Could they have charged
They
to
still
a second
can.
degree?
Yeah.
But they would have to ask the judge, right?
Well, no. They could have charged him from the get-go with first degree, second degree manslaughter, just like we saw in the Karen Reed case. Okay. Giving them the option. However, in this case, it's only first degree murder that they decided to present to the grand jury. And so the grand jury returned indictments for first degree murder only. That's it. That's all we see. Okay.
Right.
But the trial's not over yet. And at the end of the trial, the prosecution or the defense can ask the judge to add those lesser includeds, just like we saw with the OUI added, right, in the Karen Reed case. At the end of the trial, they can ask for that. So we'll watch to see if that happens. But then at that point, it's up to the judge to decide if there's not enough supporting evidence for those lesser includeds to be included for the jury to deliberate on. And then that is the legal answer. So we'll be watching for that as well. Now, this question is interesting. I wish the judge would rule on if the jury could know he pled guilty. I know. So what the judge, I agree. And what the judge is worried about is, so they know they're looking at first degree murder. Okay. And they know that they'll realize after the instructions from the judge, evidence for premeditation and planning on the part of Brian Walshe. However, what the judge is worried about is, if they're thinking along those lines, they may say, okay, well, he pled guilty to transporting a body and, misleading the police. So at least he'll get jail time for that. So we don't need to hook him on the first degree murder. So we don't want that to occur either. So that's where we stand now. But you know what? After listening to the prosecution's motion for directed opposition motion for a directed verdict yesterday, they laid down their closing argument basically. And I think based on that, it was very good. I think based on that, the jury will find enough for premeditation in this case, because I think they're finding Brian despicable. So I am dying to get to court today. I hope he doesn't testify first thing, because the stupid doctor's appointment that I have. Oh my goodness. He must have, I have to stream this to my audience. He must still have to do jail time. Oh yeah, he's going to have to do jail time for lying and hiding the body. But first degree murder is life without the possibility of parole. And those other charges, I think he can get up, somewhere 10 to 20 years. So it's a lot shorter. All right. Stream this to your audience. I got to do that. What day are we on? We are on day 9. Day 9.
Day 9.
Okay.
Norfolk indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yass for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning, Your Honor. Larry Tippett.
Morning. We need the defendant.
He is wearing a suit.
You want to put it-
Oh, okay, then he's probably going to testify.
Thank you, Madam Clerk. All right, at the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
You do not.
You do not?
Oh, my goodness.
All right. Does that moot every issue that I researched last night?
Wait a minute. He's not going to testify at all?
I just want to make sure that the 5
Not
issues that
today.
you raised
Right.
and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day.
Oh, my goodness.
Let me
Oh,
just
my
put in the
goodness.
record.
Wow.
So the record
Wow.
is complete.
I don't think I'm going to go into
The,
court today then.
Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time,
Jeez, I can't believe
he
it.
could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the 2 lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferrera, 373 Mass 116, 124, 1977 case, jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter.
I can't believe it. Jeez.
Alerted me to also file this morning 321, pause. The Commonwealth supplemental motion eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay, so just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right, on the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they have no intention, they told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I'm on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like them sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move.
Welcome to Zoom Government.
I think so.
Enter your participant ID. Please enter the meeting code. The meeting has not started.
Oh, yeah.
Please wait or try again later.
Big news. Really big news.
Sorry, I am muted. So we had been muted during this, and I'm unmuting us now, but we will be muted again as soon as the judge is talking. And so I think that Margaret predicted accurately that it would
No.
actually be the
Oh,
no, what you predict. Yeah, let me say. I wasn't
I'm
even talking about the.
sorry. I predicted that Brian would take the stand.
Yes,
Because he
but
had got,
you also what you predicted accurately was that
oh,
it would actually be the defense that motioned to tell the jury about Brian's pleas.
oh yeah, yeah, yeah. But at this point, yeah. But I figured he's so cocky and arrogant that I figured he'd take the stand. But oh my goodness, this is, I mean, this is news to me. But it was very risky move for any defendant to take the
Mr.
stand.
Walsh, if
So
you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing to be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing, so help you God?
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing,
Whether I'll testify or not in my trial.
right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
I'm muted. I didn't realize it. I was muted. I was really looking forward to a vigorous cross-examination of Brian Walsh. Kevin, I
Yeah,
think
no,
we-
that was I.
okay.
Yeah, I actually muted us both just so we wouldn't
Oh.
accidentally pick up any noises because someone had said something in chat that there were some noises coming through.
Oh, really?
So I just
Must have been on
wanted to
your
make
end.
sure. Yeah, maybe I had the TV on.
I didn't hear anything. Interesting.
No, I'm just kidding. I
Well,
didn't have
because we
the
were
TV on, but-
muted. Well, thank you. Anytime there's noises, please let us know. I appreciate that. We don't want that. Maybe it was a stomach growling.
Probably mine. I'm ready.
So this is big news. In the opening statement, Brian Tipton told the jury they would hear from Brian Walsh. They would hear his story that all of a sudden, Anna died in her sleep, suddenly, unexpected death. And now they won't hear from him. So yes, and I agree. Brian and his team seem defeated, right? It's over. They seem defeated. I can't believe he just didn't decide to do it because he has nothing to lose. I mean, he would have probably been found guilty anyway, but
Do you think he decided this overnight, or was this
Yeah.
a strategy in order to kind of keep the judge off balance?
no, I think he decided last night. I think they told him, listen, I think he was probably looking forward to testifying.
Hear ye, hear ye, hear ye. All
Beginning.
persons have anything to do with the Honorable Diane Fernandez, Justice
And
of the Norfolk State.
He changed his mind last
Just
night.
gonna mute us.
That's, I guess. Or, this week's.
I'm gonna mute us for now. Okay, Margaret.
Morning, jurors. 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case? Yes. Were you able to comply with my order that you not do any research about the case? Yes. Were you able to comply with my order that you not go on any social media or access any news media? Yes. And you still all have open minds? Yes. With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench.
This is a sidebar.
Yep.
So it's still interesting. The judge was discussing that. Did you catch that part when she was talking about what of Brian's pleas she would allow the jury to be told? There's still kind of it's not. She indicated there's still somewhat of a split decision coming on that.
Yeah, that's why they're going to sidebar. So we'll find out soon.
So you remember my prediction that she would not allow them to talk about him pleading guilty to the disposing of the body, but that she would allow discussion of him pleading guilty to misinforming the police.
Yeah,
So we'll
that's
see if that
possible.
comes true.
But that may change now.
Yeah.
Because, well, we don't know if the defense rested yet. Did they say they rested? He's not going to testify, but is he going to call any other witnesses? You might be right. I don't think they officially rested in front of the jury, so I would take that down. Wait, Court TV put that up. Oh, okay. Sorry, Court TV. I was talking to you. Oh, are we muted?
Sorry, my mic was off again. Sorry about that.
Oh,
Yeah,
okay, that was Court TV.
she asked the defense if the defense rests, and they said yes.
Oh, okay. You know what? I was texting. I was in the process of. I was posting a tweet on oh my God, Brian Walsh is not going to testify, so I must have missed that. That's big.
I was trying to explain to you. I didn't realize I was muted. This stupid mic.
Yeah. So it's just So you could be right, Kevin, but now I think she'll allow it, both of them to, she does. I mean,
I don't think she's
even,
going to allow. I
so
think she may
even
kind of.
I'm sorry, even the judge thought that Brian would testify because she had done all sorts of research on it last night. And then when they announced and the defense said he's not going to testify, she goes, well, there goes all my research. It's moot now. So
Yeah, yeah,
I think
yeah.
even the judge thought along our lines.
Yeah. And I think she did make clear that she's not going to allow the jury to learn of that he pled guilty to disposing the body. I think
Maybe
she
you're
was.
right.
I think, yeah.
You could be right.
But the more is going to be revealed during the charging instructions tomorrow.
Yeah.
She said.
You know, I agree with Tony. She blurted out that she didn't love Brian as much anymore. But you know what? At this point, I feel like at this point, Brian had nothing to lose. He's not going to, I mean, he's not going to win. And he knows it. And the defense teams knows it. So I guess I would go out swinging if I were him. I don't know. Unless he's
He
just
may have
so
just woke up
he's
and felt
done.
nervous. He may have just
Yeah.
woke up this morning and said, I don't want to face this jury. You know?
Yeah, I think you're right, Susie. I think the judge did say they'll come back tomorrow and charge them. You're right. You're right. You know, I'm just still astounded. Yeah, so we might be done for the day pretty much.
I think so.
Sort of see it as different chapters of the book. And another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth. All right? So what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really two things that happens interspersed. I'll explain. Two things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel. Right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that the crime that is charged here, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen interspersed. A little instruction, argument, more. It's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And I get the input from the lawyers of what they're seeking. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise in court, please. Jurors, close your notebooks and follow me.
couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Mutlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe, with the hammer?
No,
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that
I
transcript.
want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mutlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I'd considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I have had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday. And I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions. And I made a mental note to go back to those this morning, but I didn't frankly have a chance to do that since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in there that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction potentially, I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I am going to intend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth? The address of the refuse center, 300 Forest Street, Peabody.
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a motive instruction.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that, I mean, there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's part of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? 88 Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So-
it should have been. Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law. But I'll get it to you.
Thank you, Your Honor.
All right.
So Margaret, are we coming back at 10:30 on this? The judge, is this for jury instructions they needed? What are they deciding over the next hour?
Well, they're not going to give jury instructions today. That'll be tomorrow.
No,
They're
I'm sorry.
gonna-
I don't mean give them out. I mean deciding on what wording that they.
Yeah. Yes, they're going to decide on, both sides will, edit them, just like we edit our books and say, include this, take this out, and then she'll be the ultimate decision maker on that. I've got I can't be here for that. I will be in a doctor's appointment, so.
Yeah. So then you have to explain as much as you can to us now. So what can we look? So is there anything else that we're going to hear at 10:30 that we should be looking forward to?
I think it's going to be more like what we just heard, because the judge has to, read what the parties suggest as far as jury instructions, which will include the consciousness of guilt instruction and the fact that he didn't testify instruction. So it'll be like, it won't be that interesting, to be honest. It'll just be, a lot of what we just heard.
Standard stuff, right?
Standard stuff, and then they'll tweak it here and there.
Will the defense be allowed to make in their closing statements, the statements that they made, what they said in their opening statement, tell Brian's story about waking up and finding
No.
Anna dead next to him.
There's no evidence of that. They can't argue
Right.
that
That-
because there is
so that
zero
won't be allowed
evidence.
anymore.
So you can only, in closing arguments, you can only argue what evidence came in. So that would not be allowed. That would be very objectionable. So they're not even going to mention that. You know, because there's nobody to testify.
But it's already, but the guy, so it's pretty clever that they've already planted that idea with the jury, both in the opening statements and in some of their questioning of the state's medical examiner.
Yeah, they did.
And that-
They planted that idea, right? So all they're really getting in. So right when they cross-examined the guy from the medical examiner's office, but they really can't get into it in closing arguments because Brian did not testify that that's what happened.
Right.
So it's still guesswork.
So do you think,
you can't
is
argue
it
that's not
possible?
evidence?
Is it possible that this was the clever strategy all along, Margaret, where they knew Bryant wasn't going to testify, but by suggesting in the opening statement that he would testify, and then talking about what he was going to testify to, if he, like for instance, if he was going to say in the opening statement without saying that Brian was going to testify, if the defense attorney said that Brian's story was going to be that she died in her sleep, would the prosecution have objected at that moment and the judge put a stop to him saying that?
Well, first of all, the lawyer, listen, Tipton has to be careful because that would be unethical to have a clever defense like that. At that point, Brian most likely informed them that his plan was that he was going to testify, and I'm sure that his defense showed, okay, this is what our opening statement is going to be. So it was approved by Brian at that point, because otherwise that's unethical to do as a lawyer. You can't do that. So I don't think that was planned at that point. I think all along until maybe this morning, Brian was going to testify, and then he decided not to. I mean, the attorneys will always inform somebody like Brian, listen, we are advising you against taking the stand. All right. It's your decision, and you don't have to make that final decision until the Commonwealth rests its case. So the Commonwealth rested its case. They listened to the arguments from both sides for the motion for directed verdict. And perhaps based on that, Brian's like, waves the white flag. I surrender. I'm not going to do it. So I don't think that was the strategy.
And of course, we have seen in other trials where defense teams push the boundaries quite a bit as to what is ethical. They try to get away with what they need to, especially in a murder case.
Yeah, but this would have been different. I do not think they did that.
Okay.
I thought everyone thought, including the judge, that he was going to testify, because I do believe that during opening statements, he was, and maybe all along, he was gung-ho on testifying. I'm going to tell my story that she died in her sleep, and he believed that was a strong story. And then all of a sudden, he's like, he got cold feet this morning. I do truly believe that.
Okay.
Yeah.
His voice, he sounds kind of like a meek character.
Yeah, he's defeated.
Yeah.
He's done. He knows he's going to spend the rest of his life in jail. That's why, if I were Brian Walshe, I would have just, at this point, like I keep saying all along, if I were him personally, if I'm his lawyer, I'd advise him not to take the stand. That's just the way, this is what lawyers do. But if I'm Brian, I think I would have testified. Just, it's like,
you're going to lose anyways, so you might as well get the last word.
Go down swinging, right? He probably also looked over at the jury, and he knew that maybe they were giving him dirty looks, things like that. And he's like, you know what? I don't want to deal with these people. They're going to convict me anyway. So
I think I don't know. I mean, I kind of think that the whole thing, or at least it has the impression of a clever strategy all along. And you're going to see an argument similar to what the defense attorney Tipton made yesterday with the judge, and when he was trying to argue for a summary dismissal. And
Motion for
so
directed verdict, yeah.
yeah, right. So I think you're going to see that argument, and I think it has, at least on an intellectual level, some legs. Unfortunately, just because we don't know what happened, and the evidence of premeditation is sparse.
I disagree with that analyst. I mean, I admitted he did what? He didn't admit that he committed first-degree murder. So I
Right.
don't know what that chat is talking about.
Oh, so one of the things the judge seemed to be referring to, and I don't know if this was something you had factored in. So you had rightly predicted that it was the defense that would motion for the jury to be told about his earlier pleas to guilty. Is part of that, she was talking about whether the jury should know the defendant is going to face jail time. So if the jury was to be told that he had pled guilty on those charges, then the jury would be able to say, well, whatever happens, whatever we decide, he's at least going to face some jail time.
Correct.
So that could weigh, even in the Karen Reed case. They had to. It was the one question they had was about the OUI. So they felt like they wanted to charge her with something.
Right. I
And
mean,
just,
clearly there was enough evidence of an OUI.
Right. So was that something here that a jury could potentially be sitting there and say, well, we're not so sure about what happened as far as the murder, but at least no matter what, he's going to face some sentencing based on his guilty pleas, and the judge that the defense wanted the jury to know that.
Yeah. No, I think you're absolutely right, Kevin. Yeah.
Okay.
Yeah. Yeah.
It happens.
It's very interesting. Yeah. There's a lot of interesting things about this case. I was really looking forward to, I think everybody was looking forward to Brian going on. I was so convinced that I was ready to drive into court this morning. I'm glad I didn't. Geez, I'm really glad I didn't get up extra early and all that stuff. Yeah. Francesca, I'm sure they will. It's still a circumstantial case. And I think that yesterday, what we saw in the prosecution's motion arguing against the directed verdict, right? Yesterday, I thought they did a nice job piecing together all that circumstantial evidence. And they'll even do a better job in the actual closing arguments before the jury. So I don't think, now let's predict, how long do you think it will take for these jurors to come back with a verdict? And I'm predicting against Brian Walshe for first-degree murder. What's your prediction, Kevin?
Yeah, I'm going to predict the same thing, and I'll say it'll take an hour.
Okay.
Because they want to give it, they don't want to go in there and just take a vote and come out because of the seriousness of the charge. So I think they want to make it seem like they put in their time to deliberate at least a little bit. And
yeah, in that case, let's see. They'll read this charge tomorrow. They'll probably get the case around 11. Well, now closing arguments, then the charge. Let's see, 9. They probably get the case around noon. I bet they'll continue deliberating until they may not break. They may actually deliberate right through lunch. So I think maybe they'll take their time, like you said, with the evidence. It's a serious case, so maybe 3 hours. That's my guess.
I'm not sure what I got Kitty's question here, but I'm not sure what she's asking. If he had admitted to his attorneys, then they would not be able to allow him to testify. He has the right to testify no matter what. Yes,
he does. Yeah, because if you don't allow him to testify, and usually attorneys do not want to ask, they don't ask that question. They say, they're very clever about that. Like, okay, you're telling us this, this is the law, and we'll give you time to think about it. Something along those lines. But no, he always has the right. And that's a big deal. So what we saw today was a colloquy that the judge had with Brian Walshe in making sure on the record that he's not going to testify and that he was offered a legal advice and he's making the decision on his own free will. So that was
Yes,
a
and he
very,
wasn't pressured in any way. Yeah, I was just going to add
yeah.
that point, but thank you for doing that.
Yeah, because basically what will happen next is Brian will ultimately appeal. He'll get an appellate attorney. And one of the most common things in an appeal is ineffective assistance of counsel. So he's, he'll try, believe me, he'll try to do anything. And maybe that's one of his arguments. I would have taken the stand. They advised me against it, all sorts of stuff. So when our closing arguments, those will be tomorrow morning.
Yep. Tomorrow morning. Yep. The hole in the
Probably my
ceiling,
guess.
apparently.
Sorry.
Right.
My guess would be they'll come tomorrow. There'll be some colloquy, talk with the lawyers. They'll bring the jury in. I bet they'll start maybe around 9:30-ish. What's the hole in the ceiling, everyone?
I know there's been a lot of discussion in chat throughout the trial for this.
Yeah.
And it's good. You're always looking for
Yeah.
the meaning of something unusual that might be unexplained, but it never seemed to come into any relevance.
Right. Right.
Oh, actually, Liz says that Officer Schmidt said the ceiling hole was irrelevant to the case.
Oh, okay. Huh. I wonder what it was. Okay, well, we'll never know what the ceiling hole, unless Brian writes a book. So I don't know.
See, he sounded so meek today. Just it seems like that's his natural voice. That although we did hear he didn't sound as meek when he was in the recordings of him on the police interviews, but still,
no.
If he went up on the stand and he sounded meek like that, does that make it harder for the jury to imagine him doing what he's accused of doing?
Yeah. Yeah. I mean, any type of acting, absolutely. Yeah. I guarantee he's been reading that jury and thinking, I'm cooked. I'm done. I'm just giving up. They're going to convict me no matter what. Why do I put myself through a rigorous process? Yeah. He's waved the white flag and he's like, I am done. And maybe he's trying to think about appeal, which he won't.
Were there any? So, what were the strongest basis for appeal that you found here, if any?
I mean, he'll argue ineffective assistance of counsel, that he wanted to take the stand and they can something like that. I'd have to think about it. As far as he'll come up with something. Oh, you know what? He'll probably appeal on the grounds of the directed verdict yesterday, arguing that the judge made an error in not allowing the defense motion. So he'll probably go on that because he'll argue there wasn't enough evidence for premeditation and intent. I doubt he'll win that on appeal, but maybe that's what his line of thinking was. That's possibly what the lawyers told him to.
Barb mentioned that she knew someone that had floor above and that the blood had seeped into the ceiling. And so maybe Brian cut that out. I had wondered that too at the time. But I mean, at the end of the day, I don't think we really learned where the murder took place.
Oh, maybe.
Did you ever get a sense of what room it took place in? Or will we get that? Will we get a sense of that? Might the prosecution mention that tomorrow?
No.
I don't know.
No, because nobody tested. So I was kind of waiting for somebody to testify about what rugs were in which areas. So maybe that cut up rug. Yeah. So maybe that cut up rug was from Home Goods or TJ Maxx. When he bought those 2 rolls of rugs, maybe that. But nobody. Yeah. But the weird thing was I'm surprised that the police didn't show the person from TJ Maxx or whatever. Is this a rug that was bought at TJ Maxx? You'd think they would be able to identify that, but that didn't happen. I don't think we'll ever know. My guess is I think it happened in the living room and then he cut her up in the basement. I don't know. And I think, don't forget, he may have strangled her. So you know what I think is really important here? The broken necklace. The fact that the necklace was broken tells me there was a struggle.
Yeah.
And maybe I think he strangled her, that there was some sort of fight, and maybe when she died, she wasn't bleeding. It doesn't, he didn't have to stab her, so there may have been no blood evidence in the living room. I can't imagine them fighting upstairs with the kids, nearby.
Well, we know there was blood based on his search on a wooden floor because he had
Right.
searched how to get rid of it. And there was blood on the slippers, right?
Yeah, there's blood in the slippers, but that could have been from cutting her up.
And I know,
think-
and there's blood.
yeah.
There was blood on the butcher knife, and Jen doesn't believe, and I don't think any of us believes that would have been used for dismemberment.
No, but I think
So-
maybe he tried using it at some point. I don't know. My guess is that all of that blood evidence came from the dismemberment. I could be wrong, but I'm guessing. Again, I'm guessing. But that broken necklace is interesting.
So I think we all agree that the dismemberment took place in the basement and that the murder did not take place in the basement. We don't know where, what room. So the body would have been had to have been dragged to the basement. And if the body was bleeding from any of the injuries, then there would be blood stains possibly on the floor or, on a rug or in her, like we found it on the slippers.
Yeah.
We know that
there's
he bought a lot of
evidence. Ugh.
Yeah, so some of the rugs at least were used to dispose of body parts, but
Yeah.
was she also killed on top of a rug?
Yeah, I know. I don't
Maui
know.
says there was a blood stain at the bottom of the basement step. So that would
Yes.
suggest
Yes.
that the body was bleeding when he her to the cellar.
Or it's possible that he did the dismemberment down there and he got blood in the stairs too.
Oh yeah, that's true.
He was covered with,
Yeah.
there's a lot of blood in his slippers, so he could have tracked that in his slippers too. I mean, I don't know. But either way, I think this guy is spending the rest of his life in Walpole. It's going to be his new home, Walpole State
Right.
Prison, now called Cedar Junction, right? Or what's it called now?
Right.
I still refer
I
to
didn't
it.
know that. Yeah.
It's not called Walpole anymore.
So Francesca, I'd like to see all the evidence more clearly. There were parts that I missed in the trial, but I think, there's a chance that she was killed as part of a fight. Maybe she was hit with an object or something. We don't know because that object was not found. And that would have taken place in a room upstairs, not in the cellar. We don't know which room. And it could have been on top of a rug. There was one rug that they showed that seemed to have blood that was more consistent. It doesn't seem like it was a rug that would have been for wrapping body parts. And then I don't think it made sense to use the butcher knife to dismember or to attack somebody with. There'd be more injuries on his hands. There was one small injury on his thumb. So I think she may have been unconscious from the attack when he tried to finish her off with the butcher knife.
And this is what the jury's going to be doing. The jurors are going to be
very
having the
speculative.
same discussion that we're having right now. Guarantee it.
Right.
So that's why it might
Right.
take a little bit longer because everybody's going to come up with their theories.
Right. And you got to go around to 12 people in the room and
Yeah, you do.
give them each their say, Yeah, they do. Yeah.
Yeah. So it's interesting.
So do you think it's worth staying on here today to cover what's going to happen at 10:30? Even though it might be just kind of routine stuff, going over the jury instructions.
I don't think we need to just. Yeah, I don't know if it's worth staying live. We can always come back on. Well, I don't know unless chat wants to talk about it. I do have to, unfortunately, those yearly skin checks that are just almost impossible to reschedule just happens to be at 10:45 today.
Yeah.
And it takes.
I went to
half
mine
hour
Monday,
get
and
there.
they, as usual, they did 3 biopsies. They love to take a biopsy.
Yeah. Yeah. Well, I had melanoma. So, you know, I have to go. I
Yeah.
had it way back, but it's important to go. Anyway, it always happens that this stuff, you have an appointment, well, as you know, like on an important day. Like you have an appointment
Mhm.
tomorrow. Are you going to be able to see any of the closing arguments, Kevin? Because I'm going to run the stream.
Yeah, you're gonna run the stream. So no, probably not. I kind of depends on what time they start. I may be able to see it while they're giving me chemo if everything runs on time. But it doesn't start right away. You go there, you get a blood test, then you meet with the doctor.
Mhm.
If your blood test will tell them whether they can give you chemo, and then you go through the chemo. The chemo is the easiest part. You just kind of sit there with the IV, and then you can watch what's going on.
Mhm.
So totally said keep the stream running. So we'll keep the stream running. Even if me and Margaret aren't here, we'll keep it running so you guys
Yeah, you
can
guys can
continue
talk
in
about
chat.
it. Yeah.
And I will
He
continue to monitor
belongs
to
in
make
prison.
sure.
Maui, I agree with you. He is a
Yeah.
danger and a menace to society. Yeah. He's gonna remember, he was stabbed in prison before. I mean, he'll be when he gets released ultimately at some point down the road, he'll be a target, I think.
Mhm. And we didn't hear from Jen this morning, so maybe Jen will
Oh,
come on at some point today. So we'll
oh, that's
because
true.
her channel is here, so her audience is here,
Oh, good.
and so we'll keep it going for them too, and hopefully Jen will be able to come
Yeah.
on later.
Yeah, and then don't forget if Jen's able to come on, just text me, Kevin, and I'll come right back on and we'll discuss more.
Yeah.
So, and I'll go to my doctor's appointment. I'll try to go early. Maybe they'll take me a little early. We'll see. Wow, what are we gonna do now that we're not covering the trial?
Yeah. Well,
We'll figure it
there's
out.
always different. I'm always working. I always find different. And you too,
Me
because you're a
too.
writer. But I'm always, if I'm not on the air doing something, I'm writing something.
Yeah,
So
me too. I
I
mean,
definitely deciding what we want to write. That's really the issue. I have like several half finished novels, and but I enjoy writing. So I want to be I enjoy telling stories. So
I do too.
and I'm
I've got
always
to work on my
I'll be
writing.
halfway done a story or halfway working on a novel when another story idea hits me, and I can't help starting
Yeah,
it.
yeah, yeah. Me too. Me too. But yeah. So I'm disappointed. I wanted to see a vigorous cross-examination. I was so looking forward to it. I was thinking about it last night. I really thought he was going to take the stand. It's almost like a wah wah. I
Yeah.
don't know.
Yeah, especially after watching hours of clerks testified that yes, this is Brian buying something. The only interesting thing we were looking forward to was his testimony.
Now, what about that long day of DNA? Oh my
Yeah,
God. You and me. Oh, that dragged. Oh, that did drag. I'm surprised they didn't stipulate to some of that stuff. So we didn't have a dozen or so people come on to testify as to their little step by step. Oh, and then this person did the next thing, and then this person did the next thing, and analyze this.
I,
Wow, that dragged.
Tully says we're muted. I don't think we're muted, Tully. I'm looking at everything. Everything looks good, so it might be on your end.
Yeah. Can everybody else hear us? I think they can. I'm not muted.
Yeah, looks like everything's on. Not muted for Deborah, so it's on your end. It happens, Tully. We
Welcome,
always figure
welcome,
these out together.
welcome, kitties. There was a big crash just now. That was my kitties in the other room playing. So you must like kitties. I have 3 kittens I'm fostering. Well, I'm going to keep them. Foster fail. God.
Now, you didn't like the DNA testimony, but Music by Brian did because that was his field. He's over at Jen's
Okay.
channel. So, Music by Brian, I don't know if you'd be interested, but if you could send me just an email at some point, because I would like to be able to occasionally, we have in other cases questions about DNA that come up.
Yeah.
So if you didn't mind emailing me, it's leitskev@gmail.com. And that's just so I can email you back if I have a question. Like, for instance, the question that came up for me that I remember was in the Delphi murders, where the girls were murdered a couple of hours with their bodies, and the bodies were found 24 hours later, but they found no DNA. I just always wondered and I think Jen had wondered that too, what the possible expert explanation for that is. Can that DNA deteriorate in just 24 hours from being outside in the weather? It was in February. I don't believe it rained.
That's a good question. Because I know DNA can deteriorate. What if it's in free? I don't know. That's a good question, Kevin. Yeah.
We always want to have these experts that we can go to, or people that are experienced.
Yep.
Just putting up my email on the chat. So I added my email to chat too, if you want to get it from there, Brian, but it's leedskev@gmail.com. And anybody's welcome to email me if it's polite and civil. Even if you disagree with me, I still have ongoing conversations from people that disagree with me in the Karen Reed case that go back 2 years. And if they're civil, we're still friends and we still have those conversations. Sometimes it breaks down. So if you're on the opposite sides of me, it depends. But as long as you're civil.
Yeah.
And I am also somebody that is willing. I'm not married to any opinion. I'm always willing to change my opinion on anything if there is a stronger argument or better evidence. I changed it before in the Karen. So that's always the way I will be. If you've got the better argument or the better evidence, I'm willing to learn.
Yeah.
That's a big part of trying to get to the truth is recognizing that we're all wrong sometimes.
Yeah, you always have to look at both sides. And that's where they train us as lawyers, from law school. You have to analyze the other side and have respect for their arguments in order to argue against them. And I think you do a good job.
Yeah. No, right. As a lawyer, how can you possibly anticipate? You want to be able to anticipate what the other side is going to throw at you. And you can't really anticipate it unless you can put yourself in their shoes and imagine what arguments they're going to make.
Yes. Yes. And you have to, so you develop a new case comes in, no matter what side you're on, the first thing you do is you develop your theory of the case, your theory of what happened. So in order to develop that theory, you have to come up with a theory for the other side too. And just always have the thread running through your arguments of the theory of your case and develop that theory all the way from, opening statements through closing arguments. So it's very clear for the jury to understand, okay, this is the, prosecution's theory. Are we buying it? So everything has to go to the theory, and you can't get lost. You don't want to get lost and sidetracked from your theory of what happened. But again, you have to have to be able to counter what the other side's going to say.
Right.
So
here's a question for you.
Ryan.
So maybe from a historical perspective, why is it that a defendant it's in the Constitution that a defendant is not required to testify? But what do you think is it just the right against self-incrimination, or what is the main reason for that? And it was obviously so important that the founding fathers put it in the Constitution. But what do you think? What's the argument for that, Margaret?
Well, it's the Fifth Amendment right not to incriminate yourself. I mean, it's
why is that there though? Yeah.
Why is it there?
Is it just the right against self-incrimination, or?
Yeah, can you imagine if you were forced to testify and, I think you just have the right to remain silent is sacred. And I imagine so back in law school, I took a class on our laws going all the way back, to Britain. And because we're based on the English,
common law.
Yeah, common law. So I believe that goes way back. And I can research that for you. I can't remember where it originated, but it's been, a long-standing principle in English common law. You know, you're innocent. You're innocent until proven guilty. So the defense has to come up, I mean, the prosecution has to prove beyond a reasonable doubt that you're guilty. And so you don't have to do anything. And that's a long-standing principle of common law. Who came up with it? The guy that came up with it, or the woman? I don't know.
I don't think there was one person. I'm sure it evolved out of the context of specific cases that were taking place in English history. And it probably, evolved. But I would be curious as to what the philosophical arguments or the legal arguments are for its existence. But obviously, see, the Constitution, the founding fathers were very concerned about any violation of our rights, because that had been what the revolution had been fought over. So they were worried about, they were enough worried about it that they enshrined it.
But that particular right may have been embedded in English common law well before the Constitution.
I think it was,
Yeah. Well before, the Revolutionary War and the Constitution. But
and it wasn't put in the original Constitution. It was put in the add-on known as the Bill of Rights. So it's now part of the Constitution. It wasn't.
But it's the same with it, like the First Amendment. Obviously the First Amendment, number one, right to free speech, and freedom of religion. So that's first. But I mean, Fifth Amendment is number 5, so it's pretty important.
Right, and that's what we're as we watch these trials, it's easy to sometimes say, this person is guilty, just throw him in jail. But there are principles of law that are there to protect innocent people in that situation. So that's why these principles of law are so important.
Can you imagine? Make him if the Commonwealth could force him to testify. I mean, that's even if you are innocent. Let's say you're an innocent person and forced to take the stand. I mean, that's not fair, right? So
I'm just refreshing. I do that once in a while to make sure.
Yeah. Well, I've got to get ready for my doctor's appointment. So I will. Thank you. Well, and I'll be back. I'll text you when I'm coming back. So I will take my camera out for now, or whatever.
So what? You must have forgot about the doctor's appointment yesterday when
we
were talking about going to court. Yeah,
I did forget about it. Well, I knew about it earlier in the week, and then I was so excited about possibly seeing Brian Walshe testify that it slipped my mind. And then last night I looked at my phone and I'm like, oh my God, I have this stupid appointment. And then I was thinking, I need to be able to rush in and hopefully, I figured he'd be will he testify first thing and all that. And so now it doesn't matter, but I still I will be doing NBC tonight. Commonwealth Confidential between 7 and 7:30. So I'm sure we'll be talking about all of these issues on Commonwealth.
Is that 7 o'clock?
It starts at 7. It goes from 7 to 7:30. And I'm not sure what time they'll have me on. I'll be sitting at the little round table there and discussing what's happened in court today. And I'm sure the whole thing about Brian Walshe deciding not to testify. And so I'll have to think of something clever to say that hasn't been said already.
Well, maybe you can take something from chat and one of the questions or comments that people made, and that's inspired you to go on TV with.
Well, I do think chat is important. Chat comes up with some excellent ideas and things that, like that broken necklace, I had to be reminded of that, and then that's a big thing.
Kitty's became a member of my channel, so thank you. We have to get your channel up to where it's monetized, Margaret, because these membership things really kind of keep us going, because there's actually there's expenses that are involved with this, the StreamYard and editing things and stuff. So we'd like to get it back to where at least you're breaking even on it. And so I appreciated Kitty's. And
I like that name, Kitty's. I love it.
Margaret's channel, she needs members to get. You have to have membership and a total viewing time. I forget what that is. Maybe 1,500 hours.
No, it's more than that. It's
more than that now.
You have to have 1,000 subscribers, and in order to do memberships and things like that, you have to have, oh my gosh, 3,000
I think-
watch time
Oh,
hours.
3,000 now.
3,000, but then for YouTube ads and stuff like that, you've got to have 1,000 subscribers and 4,000 watch time hours. And it takes a while to build. I mean, I was a podcaster, and I had, I still do. It's a Crime with Margaret McLean. And I didn't start YouTube until, I sort of signed up for it less than a year ago. And it was my son that convinced me to do it. Mom, you need to do YouTube. And I started to do it. And then, you have to find your way, and I'm happy with it. And right now, I love the fact that I'm interacting with your chat, people in chat, and building my channel. And then you find your way. What are you good at? What are you not good at? So it's very interesting to me. But thanks for the plug, Kevin. I appreciate it.
My channel actually became monetized. I got a lot of growth during my analysis for the Delphi murders. And so I was actually monetized before I began covering this case.
That's great.
And I jumped on that case late. It was, and it was because of someone in chat. So actually, when the first burst of growth that I achieved was when I first started putting myself on the camera, discussing the Lizzie Borden case. Before that, I would script out the show and have a more professional narrator do it for me. They would read the script, and then I would edit it. And then when I started talking about the Lizzie Borden case, because I knew the case so well, that got me the most growth. So I ended up narrating that one myself. And it was somebody in there that suggested that I do the Delphi murders, which I was really reluctant to do because it involved kids, and I just didn't think I'd be able to do it. So, but I went into it, and at that point, it was about 6 years after the murders. And I went deep into
That was
all
my
the
question.
documents.
Did you do it during the murders? Okay. That's interesting,
no.
Kevin. Yeah. When was it? What year did you do the Delphi murders?
So I think it was, so when I first started covering them, it was only about 2 months before they actually, ironically, arrested Richard Allen. But it started growing because there's a lot, that was a huge case. There were millions of people following that case, but most of them were going down into crazy land.
Oh yeah. You know what? I'm going to be late for my appointment. I'm just sitting here talking and talking. I've got to go, but I'll be back.
Thank you much. We'll keep the stream going, and maybe you'll be back in time after.
Sounds good. All right.
Thanks. Good luck.
Thanks.
Okay. So anyways, I'll just finish up that story. So when I was covering the Delphi murders, and you guys know I don't have experience. I have no criminal, experience from criminology. I didn't take any classes in it. I'm not from law enforcement. I'm not a lawyer. So you're just kind of the everyday person like you guys, just applying your thoughts to the crimes. And when I was just looking logically at that crime, I eventually came up with a profile of the killer, which I'm unqualified to do. But coincidentally, about 3 weeks after Richard Allen was arrested, he weirdly matched my profile point by point. So there was a time when I got a burst of growth during that case because of my kind of common sense approach to it. There was a lot of people out there that really just believe the wildest, like devil worshiping conspiracies and stuff like that. So I didn't go down that road. So there was a certain segment of the online world that wanted to hear somebody talk sane about it. And so that was, I got a lot of growth through that. And those videos that I would do for that got way more views than I did for Karen Reed, believe it or not. But then, of course, after they arrested Richard Allen, interest in the case by everybody, including me, went way down. I made a friend who, I'm not going to say his name, who I still talk to on the phone every couple of weeks, who had been in law enforcement, federal law enforcement. And through that, we became good friends. He lives in Ohio. And he followed the Delphi case very closely. He even actually traveled out there with his son to kind of inspect the scene, to come up with his own opinions. And of course, and Jen, Jen Coffeneffer, has done a lot of work on the Delphi murders too. She doesn't agree with me. I ended up, you know, to me, Richard Allen was definitely the killer. She has her doubts about that. But she's always had a different opinion than me on that. And I think part of it was the FBI made some mistakes on that case early on. And I think that maybe Jen, because of her past employment with the FBI, I think maybe that misled. I think that took her down a different path. Let's just put it that way. Yeah, the closings will be tomorrow. So I am going to let you guys go and keep this going and monitor it, unless anybody has a last question for me before I get off. But I will keep my eye on the screen. I agree, Maui, just to make sure it's always refreshed and the clock is moving. You can see at the bottom of the screen the movement of the pendulum. So everything is wrapped up very quickly here. The defense rested. Brian did not testify, taking everybody by surprise, including the judge. And so at 10:30, they'll be back. And I think the main and only order of business at 10:30 will be to discuss, both sides have to discuss the wording of the jury instructions. Yes, check from the defense rested, and Brian did not testify. So the jury's been sent home, and the lawyers are now working out, finalizing, I guess the right word, because I think they've already put some of this in, how they want the jury instructions to be worded. That's very important, and the judge decides that after listening to both sides. So we'll hear some arguments on that at 10:30 when they come back, and then be done for the day. And then we'll be back tomorrow for finishing up on the jury instructions and closing. I think that'll be done on that, but we'll get closing arguments, and then the jury will be instructed, and then deliberations will begin. I will probably not be here for most of it, maybe all of it. I have to go for medical treatments in Boston, and I have to arrive there at 9:30. But we will have the channel up and running, my channel, Jen's channel, and Margaret's channel, all three, just as we always do. I just won't be commenting. I may actually be able to comment a little bit from the hospital in chat. But I'm hoping I get to see closing arguments live. I may not. I will have my computer with me though, so I'm hoping that closing arguments are timed to when I'm getting chemo, because then I'll be able to watch them. All right. Nobody has any questions, so I'm going to take myself out, go have breakfast, and we'll keep this up. And the judge should be back about 10:30, so in about 13 minutes. Joe, our moderator, is correct that the judge basically gave them to between 10:30 and 11. So they're still working this out. 10:30 was not a firm deadline to get this going. There's no jury waiting. So it's just a matter of when the lawyers have agreed on their wording, and then they inform her that they're ready. Got my winter hat on. I just bought this. So Amazon's crazy, right? I ordered it last night at like 4:30 in the afternoon. I wanted a hat that would cover my bald head and my ears to get in the winter when I go out and do the shoveling. It came at 6:44 this morning. That's crazy. But this is nice. It covered this. I've never had a hat that covered my ears. This one covers my ears. Let's see if anybody has any questions or comments in chat. Thank you for being here. Our audience dropped down once we got off the air and they went to the break. So, but we still have probably 100 or so people watching from the various channels. Yeah, it's the wind that gets you, Deborah. I don't mind the cold, but it is definitely the wind that gets you. And this hat was only like $15 or something, and it covers. It's set up longer in the back, so you can. It's very warm. I'm actually probably going to start overheating now. I'll have to take it off soon. Mindy says she wishes the judge presided over the Karen Reed trial. Thank you, kiddies. You actually already joined a couple hours ago, didn't you? Oh, there's two kiddies. Wow, you have two accounts. So I have you joining as a new member at 9:56. And then I also have you joining at 10:42. Okay, thank you very much. We appreciate it. Thank you, kiddies. Appreciate it. Yeah, when it became monetized, I had to set those things up. It was something I hadn't had any time to give any thought to, and never expected anybody to actually use. But when you get monetized, it's an automatic thing. When you set it up, you have to do it. So I put them at the minimum amounts, and the idea is you should be able to give people something back with that, special shows or something. But I haven't really been able to figure out ways to do that. So at this point, it's basically just people's way of supporting the work. And so I appreciate it. With Brian purchasing so many buckets, it's really driving me nuts. What are your thoughts on what he did with those buckets? I mean, we don't want to get into gory details, but there's a mess that he was anticipating having. And it's amazing when you hear him speak today in court. He sounds so meek. So but here's this guy that is not only was capable of the violence of killing his own wife, the mother of the 3 children that are in the house, but then dismembering the body. And so I guess you never really know what somebody is capable of. And someone that comes across as meek as this guy was capable of that. And so we as amateurs, based on how we see him acting in court and after being arraigned, we have diagnosed him as a psychopath. But let's assume that's correct. Did anybody else see that before in him? Well, apparently not. At least there's no evidence of it. But psychopaths wear masks. They can mimic normal people. I would just assume the buckets went in the dumpsters, wouldn't you think? I don't know. What do you guys think, Lori? I think maybe just in the dumpsters. Or maybe not, because if you put a bucket, well, it depends what's in the buckets. But if there were body parts in the buckets, and you put them, I guess that's more likely to be discovered by the trash people than something rolled up in a carpet. Lori says the buckets are never found. So yeah, I don't know. I mean, if you're gonna dump that, like to use those buckets to dump parts in the water, why would you put some body parts in with the trash? Joe points out no complaints from Anna about him as a husband and a father. So the monster inside him, he kept hitting for the most part. Now we knew he was not a good guy because he was, selling people fraudulent art for hundreds of thousands of dollars. But apparently nobody ever anticipated he was capable of this kind of violence. Although there was Anna called the police before they were married on one incident there. And I believe he was actually diagnosed as a sociopath, right? I believe that's the case. So Joe points out that a lot of the items that he threw out went to the incinerator, and it was too late for law enforcement to retrieve them. So they may have gone to the incinerator. The 3 kids are not in state custody. They're with somebody connected to the family. I guess that's all we're allowed to say. That doesn't mean that the state isn't monitoring them. But they are not in, like, for instance, foster care or something like that. No. So would you guys want to be on a jury like this for a murder trial like this? How would you feel about having the weight of having that decision? You have to decide whether somebody is going to go to jail for their life or for a very long time. How would would you be able to do that? Would you be comfortable being on a jury that's deciding something like that? Lori says she would, and Joe Bai says no, she doesn't think that she would like it. It's a lot of weight, right? Oh, it looks like we're coming back. All right, good. Let me take the comment off. Or at least we're moving down to the pendulum. That's a very nice clock in there. Maybe we're not coming back. Maybe they were just giving us a different view of the clock. Lori wants to volunteer for jury duty. But the problem is, it sounds like you had your mind made up. Not that you were wrong in this case, but it's not, could you hear a case impartially if you've already made up your mind based on what you've heard in the media? That would be the question. I've never been inside this courthouse, but I've been outside it, and the area is beautiful. The courthouse is really nice. It has a very old colonial look to it. That area, that street, it's really nice. Just Jennifer said, no, I could not bear all the images and such of the most of these awful trials. However, it wouldn't bother me a bit to put an evil monster in prison. Overall, I'd be afraid what I'd have to see and hear. So, Laura, you still feel you'd be, even though you had formed conclusions, as we all did from the media, you'd still be able to be fair and impartial. And I could accept that. I think I could too. So I really would like. So Jennifer told us about her nephew and her niece that are book authors. I would love to get them on the channel. Would any of you guys be interested in seeing that? So one, her niece is an author of sci-fi and fantasy novels, and her nephew does nonfiction. He went down and helped discover a new tribe down in South America. So a tribe that had never been exposed to the modern world or modern people. So would you guys? I would be interested. I want to have them on because I would be very interested in talking to both of them. Would you guys be interested in either or both of those two as guests? So would even if you don't read sci-fi, if you're talking to a sci-fi author, it's fun because you kind of get to discuss their speculation on where we're going in the future. And even if you're not a sci-fi writer or a fan of sci-fi, that's probably something you might have thought about yourself or may have some interest in. What's our world going to be like in 10 years? We see it changing very rapidly. What's it going to be like in 100 years? And as for her nephew, the anthropologist, that's interesting to me too, because I've studied this. So, for instance, one of the tribes that had been uncontaminated by exposure to modern people, when they went and they sent someone that was spending time with them, living with them, and learning about them. One of the things they learned was this particular tribe had no words for numbers. They hadn't developed numbers yet. They used a kind of counting, a rough counting that would go up to like 10, but they never even had assigned it specific numbers. So they had a full language, but they didn't have numbers. Other tribes may not have other concepts. Like, for instance, some tribes didn't have a word for the color blue. So did they perceive blue? There's just interesting things. The jury has gone home, Lily, but the lawyers are still there working. What they're working on is, and they're supposed to come back any moment, is the wording of what the jury instructions will be. Oh, Deborah, that's very nice of you to say. Thank you very much. I know we're not that exciting here, but I'm just someone that's been, like a lot of you, interested in a lot of different things, a lot of different subjects. And so I'm an expert in none of them, but I'm in them. So I like to ask questions of the expert, people that are experts in them. Thank you, Joe. So my book is called Storm of Suspicion. It was published by Wild Blue Press on April 1st. It's to do with the Karen Reed trial. And though, as many of you know, I have certain conclusions on it, I treated both sides very fairly and objectively. From that sense, it's kind of dry, I guess. I'm going over evidence, but I also went over my experience in this case, how I began covering it, what I was going through in my life, and some of the stuff that happened during this case as a result of my coverage of it. It's a little bit of a mixed batch in that. So I'm not sure. It's hard to make it as exciting as some kind of a journey of discovery, but for me, I began the Karen Reed case, on April 18th. That's when Turtle Boy's first article on the case came out. And now we know that the week before, the defense had, in a motion to get Brian Albert's phone, they had first revealed their conspiracy theory about John being killed in the house. But Turtle Boy didn't get it from that. Turtle Boy got it because Karen's team, Karen herself, chose him and reached in order to push their side of the story, and they reached out to him. And so they had to convince him, and over a course of a night, and I've seen the questions through Natalie, and he was skeptical at first, and he did ask a lot of hard questions, but once he decided to go with it, that's it. He never asked a question again after that. He stopped asking questions because he had hitched his wagon to the Karen Reed train. So on that same day, that article came out, I was talking with Dave McGrath about whether or not to cover it. And I called Thomas Fleming. Should I cover this? I had some misgivings. And Tom said, why not? He kind of leaned towards doing it. So I did it. But for those early months, and again, so many issues in this case about trials or about police investigations work. I was ignorant, like most people in the public are, and even frankly some lawyers, and so it was a learning experience. But I began out believing that data was data because all we had was the defense document defense side of things at that point. So I thought 227 was not in dispute, that Jen had actually made that search at 227. Now, had she made that search at 227, I still say, yeah, there would have been something fishy that had gone on. There's no way she would be making that search, and coincidentally, John was dying on the lawn at 34 Fairview doing that. So we now know that she didn't make that search at that time, but we didn't know that then. And so with that, you start thinking, you're trying to piece together what actually happened in this case. What did they do? What did the conspirators do? And so I kept asking hard questions, but nothing made sense. Why would John be found? Why would they put John on their own lawn? Why would they put him there alive? Why would the phone be found underneath John's the hype button? Why would the phone be found underneath John? How did that get out there? And you look at the calls and different things. And so, I started out, I guess, maybe exploiting the public's interest in conspiracy, to be fair. But at the same time, I was asking questions, and my conscience was looking at the way Turtle Boy was treating the witnesses, particularly when he showed up at the lacrosse game of the McCabe daughter, and the way he asked Matt and Jen in the stands. Kept asking questions. Am I exploiting this? Am I, I'm looking at crowds, angry mobs taking pleasure at the tormenting of those people. And so I kept asking, and then during the summer, then we learned that the state was disputing 227, that they had their own expert. So I kept asking harder and harder questions. But it was hard because everybody on my team, about 12 people on this part of this channel, was pro Turtle Boy and pro pretty much FKR at that time. And especially my two co-hosts, Dave McGrath and Aaron Walshe. And so people in FKR started really attacking me hard just because I was trying to take a position on the fence and ask questions. And so, for instance, Dave reported to our audience that Rich Green was one of the top forensic data people around, and that there was no question of the 227 search. But that turned out to be false, completely false. But I didn't know that, and he told me he was studying it in school, and so I was in a difficult position. But I also, I didn't accept. I refused to accept that. Even in fact, Tom was not happy with me, my moderator, that I wasn't accepting Dave's opinion on that. And but at that point, it wasn't adding up to me. So I just had questions, and as my questions got harder and harder, eventually I had kind of the outburst episode when I went off at Turtle Boy, which I don't really, I'm not proud of. In a way, I'm not proud of the way I did it. I'm also not proud that it took me so long to do it. I should have done it months earlier. And so, none of us is perfect. It's a growth, you live and learn. And I never had talked to Kate or anybody from the other side before that. And then after that happened, they started reaching out to me. And so I became very good friends with Kate. She is extremely intelligent. So, it was a pleasure talking to her on the phone all the time. And other people that became sources, but they all reached out to me. I wasn't reaching out really to anybody. I didn't talk to really any of the witnesses at that time, with the exception of Chris. He reached out to me, and I became friends with Chris too. He came across as an honest guy, and a guy who just loves his kids and loves his family. And so that's how that evolved there. But it's important to me to remain objective and impartial on any single piece of evidence. All right, Safari says, Kevin, on Vinny last night on Court TV, at the bottom of the hour, he said that Karen's vehicle is going up for auction. I don't know anything about that. No, I mean, I've heard that, but I don't have any sources or anything. Well, I assumed that going up for auction would be Karen's putting it up for auction to raise money. Yeah, that's Joe just said that. Yeah, because Karen, it's been returned to Karen. We know that. She was acquitted. The car has to be returned to her. Heartstar, I'm not sure. Is that like a donate button? I'm not even sure what you're talking about. But I'm not looking to add anything like that. Not really looking to raise money, just enough money to keep the channel going, and enough right now. Enough's coming in from the memberships and the small donation here and there, and that's enough. You can hype creators' videos, and there is a leaderboard. So, like, I can hype somebody else's videos. You mean? And there's a leaderboard. Yeah, that sounds interesting. I don't know what it is. YouTube is always going to try to find new ways to add things to its channel. I don't really get into the business of fundraising, for whatever group or whatever. And I also don't hype other channels, unless they're partners of mine, such as Jen's channel, which is Breaking the Case with Jen Coffenaffer, or Margaret's channel, It's a Crime Media. It's free publicity for me. So they would have to hype my channel, though, right? Is it a reciprocal thing where two people work it out that they hype each other's channel? I don't know what it is. I'd have to see it demonstrated, I guess, on it. Maybe there's a YouTube video that demonstrates it. I haven't got any notifications from YouTube about this particular feature. Usually they send you some kind of a notification. So I don't know where to look for it. You guys hype the videos. Exactly. Thank you. JB Auto in Weymouth bought her car's lease. Karen stopped paying during the trial. Okay, makes sense. JB Auto said all proceeds would go to Karen Reed. there's a lot of grifters on this case. Everybody trying to take advantage of it, including Adam Deitch, running now from former assistant U.S. attorney, now running for Morrissey's seat as district attorney. So he was a former assistant U.S. attorney. Did I say that right? So a Fed from the Karen Reed case, and now has left the U.S. attorney's office. My information is that he was pushed out by the new U.S. attorney, and he's moved to Norfolk County so he can run for district attorney, which is a state position in that county. And he's hoping to capitalize on FKR. And he got endorsements from Bill Reed, and which was followed by all the FKRs. All right, we're finally getting an action here. Let's try to get this stuff off the screen.
Your Honor, we're back on the record in the matter of the Commonwealth versus Brian Walsh, indictment 2023-0091.
All right. Let me make some space over here. So I know you haven't had a long time to look at them, but we'll take a stab at seeing how far we can get today, and then we'll reassess whether we need to charge conference a little bit more tomorrow. All right. So my approach to charge conferences is pretty informal. And so what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way? So an edit or an extraction or an addition. What's the first page for the Commonwealth?
Your Honor, I'd say pain going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number 1.
Page 1?
I think it is. She just took it.
Are you joking?
No. It's, I'm sorry. Premeditation. I'm sorry. I have it 1 here, but I meant what my notes are saying. It's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1. That
We'd be here forever if we were starting with page.
All right. So what page?
Page 6, and I'm just lodging my objection, Judge, to otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. Paragraph 1, I am asking that the section be regarding the timing of premeditation be removed for reasons I stated in the motion.
All right. I read your motion. Denying your request to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
Mm-hmm. So 15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9.
Yes, counsel.
The instruction parentheses B,
Yes.
use of a dangerous weapon.
Okay,
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence of, no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Anna Walsh. And so what the jury is being allowed to do.
what about the breadcrumbs that the Commonwealth put down?
What, the breadcrumbs?
Well, why don't you argue, then I'll let them, I don't want to make their argument for them. That would be, but I want to get to the right answer. So go ahead and you argue, and then they'll argue, and then you'll have an opportunity to rebut.
I understand the admission of the exhibits, and I understand the admission of the hacksaw, but to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that, and just speculate as to, well, this was used, this wasn't used, that is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used without any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion, and I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Anna Walsh. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant throwing that bag in the dumpster. That's prior to the trip to Lowe's or to any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here, and would ask that the court keep that instruction in.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
No, I didn't hear her say knife just now.
There was a search.
There is the knife above the.
There is a knife, but there is also a search in the web history in the defendant's.
I remember that. And
regarding.
it was, the search was specific as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
Your Honor, may I? I believe that I can answer this question. There is a slate.com article
Right.
that the defendant went to that was regarding getting, can DNA be removed from a knife?
Yes,
Then the dishwasher is,
following that, right?
is follows that, and it's, can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on the, I think it's Exhibit 79, is that right?
It's Exhibit 79.
All right,
And then page number 4, the DNA off of a knife,
yes,
is page 578.
let me
That's-
get there.
Okay.
I'm there.
Okay. Then 70.
Hold on, I just want to look at these.
Sure, I apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA off of a knife? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together, when was the, Vinton's Liquor is also on the 1st, it's at night, because I remember it being a little dark. What
Yes,
time
Your
is
Honor.
that?
It's dark at at Vin and Liquors.
5:30, 4:30,
About
something like
5
that?
p.m., Your Honor.
All right. Okay,
And so if you were to go to page 670,
yeah, let me get there. Yes.
and if you were to go to record 2430,
Does the dishwasher clean blood?
yes, Your Honor.
That's at 1-1 at 152, also before the,
Vin and Liquors.
right.
And then on page 671, there is record 2433. Is it possible that a knife that,
Which
this-
had blood on it remains contaminated after it's been washed with hot water and dishwasher soap.
yes, Your Honor.
Mhm.
And so,
And above it, does a dishwasher clean blood?
yes, Your Honor.
Mhm.
So I think earlier you referred to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see the way, what our argument is that those searches show the reasonable inference that a weapon was used.
All right, there are the breadcrumbs. Attorney Tipton, back to you.
Oh, I'm not going to repeat what I said. I understand the breadcrumbs argument. However, I would ask then, I think I see the writing on the wall, that the instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used, or words to that effect to help guide the jury to avoid speculating about any and all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon and use it to find the defendant guilty of first-degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite completely in other parts of the instruction. But I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. As of this time, the instruction is going in and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs. Which, this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns. And I'll be open to seeing whether there's something else that needs to be added to make it more easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right, so now we'll move to the other side. What is your, I'm moving to page 15. Did you say 15 into 16?
The impeachment by prior conviction,
Yes,
and
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being impeached.
That's probably because when the defense, I lifted it from your instructions and at a time when I think that was the expectation, but let me go back. Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence, they have through stipulation, right?
Yes, Your Honor,
That sentence is okay.
it's on the next page, only for the limited purpose, and I suggested
I see,
limited
I
purpose.
see, I see. So does the whole thing come out?
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand the complete circumstances of the situation in the home at the time of the events at issue here.
Well, I don't like that.
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose and.
Well, but it's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh. So it just seems to me like it should be out.
We think it should be out.
Then maybe it should be out.
I mean, it's no longer impeaching him, and the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right, my present ruling is that's whole section's coming out now. The reason the impeachment by prior inconsistent statement is now in italics is, I'm sure that happened with some witness, but I'm not 100% sure.
I don't think it's
Ready?
fair. I don't want to speak.
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but there was some questioning of some witnesses about something they had said
Yeah, I
previously.
just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem yesterday, Mr. Mutlu yesterday, and that wasn't with a prior statement. It was his prior statement, but he just said, I don't remember. So was that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about? So I'm inclined to take it out.
And we have no objection.
All right, that's why it was in italics before.
Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
It's an interesting question.
There's many interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel? Is it prior to this time? Is it prior to the crime that was charged?
It's arguably subsequent, Your Honor, but,
Right.
I mean, it's arguably.
What about the lying to his federal probation officer?
That would appear to be a bad act, arguably a subsequent bad act, but
Yes.
I don't want to interrupt. I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6. And I took it from the Massachusetts Jury Trial Bench Book, and I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if they believe that the body was disposed of in bags, anybody's going to think that's a bad act. And they need to be instructed that they can't, he was not charged with anything, and therefore they can only use that evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse.
So I'm looking at your instruction right now, and that really deals with the art fraud, right? Are we on the same page,
Yes,
Attorney
we are.
Tipton? But are you suggesting, I just want to make sure I understand what the respective positions are. Are you suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Anna Walsh?
Well,
and the lying to the probate. So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
yes.
Okay.
But
Do you want that to be included? So in the proposed instruction, and just so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Shipton. Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
yes, Your Honor, I was anticipating there to be a proposed other instruction like you had, but yes,
Okay.
I would ask then that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes in that defendant hasn't been charged with committing any other crimes other than murder. I'm just pausing there because if I move the the federal art conviction in, somebody could wordsmith that and says, oh, yes, he was. He pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder. You looking at the first sentence?
Yes.
Let me take a minute. All right, so if I say something along the lines of, the only charge the defendant is now facing is the you've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Anna Walsh and or lying to his federal probation officer. So all four things would go into that parenthetical. Okay, and then I would pick up with what the defense has. You may not take the defendant's prior acts as substitute proof for that they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right, what do you think about that, Kamala?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Anna Walsh, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
So you're not,
Then I go back, I don't think that's appropriate to add the for one thing.
the last two sentences?
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to, I don't know what I do about the other things. Because you can see the issue that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of, because it almost seems, I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Anna Walsh.
Well, that consciousness of guilt is before here, isn't it? Maybe?
I believe it's on page 27.
Oh. Hmm. Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction. What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, my comment would be I'm objecting to the consciousness of guilt, so
I know you are. I know you are. It seems to make more sense in that area. So I'm going to move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, you let me know when we get down to page 27, recognizing you don't want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. To be continued on tomorrow if we need to discuss it more.
and I understand the court's not going to include the last 2 sentences, so I'll just lodge my objection.
Okay. So lodged. What's the next edit that the Commonwealth has?
I'm 11.
What's the next edit the defense has?
27.
Nobody likes penny 27. What did I do on that page? Let us see. Okay, that's COG. Who wants to go first with what I got wrong?
Your Honor, I would suggest here in the italicized language,
Yes.
in the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Anna Walsh's body. I would just suggest that that should be tried to conceal the disposal of Anna Walsh's body. And in the
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
correct, Your Honor, that's accurate.
What do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
All
accurate.
right, so what do you want me to subtract?
Rather than saying taken steps to conceal the disposal of Anna Walsh's body, it's tried to conceal Anna Walsh's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
So you've taken steps to conceal Anna Walsh's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to
conceal the
disposal of
body,
it.
not the
Yes.
disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate. So under the Commonwealth's request, I would delete the 3 words, the disposal of.
Will you add the word try?
What do you want me to add?
Try. I thought I heard the Commonwealth asking for try.
Commonwealth's content with how the court articulated the.
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about tried, not waiving any argument to the conscience.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
In the next paragraph, Your Honor, in the italicized, defendant did attempt to information, I believe it would be did provide false information.
And there I got the language right in the second attempt in terms of what you just pointed out in the
Yes, Your
earlier paragraph. Even a blind squirrel finds a nut every once in a while. All right, any other edits to that consciousness of guilt instruction? Recognizing the defendant doesn't want it and that objection is noted and lodged.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And
Mm-hmm.
on page 4,
Yes.
I'm asking that that be included. And I modeled that trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's the district court. And the heading for that supplemental instruction that's included refers to where evidence is of it, where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank intended,
Right.
and that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding this other instruction, is because I think just the title alone draws attention to the jury, where they're hearing a different instruction entitled consciousness of guilt.
Mm-hmm.
And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, my opinion, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear and the instruction says they can't rely on consciousness of guilt evidence alone. And I think it then, since we don't want the instruction in the first instance, at least it gives them better context for how to apply what they may deem to be consciousness of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after.
Right.
Because
I guess I'm just pressing this supplement, primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right?
Okay.
And of course, you know this is coming, so you will, I am sure, as you all, I know you will. You're going to take those parts of my instructions that you want to highlight to the jury put them in part of your closing arguments. And so you'll know where it is and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including this one. But anyway.
I may, but.
Or not.
Having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instructions?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those instructions until after I've read it to them, made those edits, and I sort of a running game I have with myself. When are you going to get it right? Exactly right. Hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I used to just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome, so I've now changed it. I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it, and that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing, that I can give them. So if that answers your question, that's how we'll do it. Now, you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23?
Oh, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is the more modern version of that. But if you want to propose some language, I'm not adverse to explaining it.
I'm just objecting to any additional language, and I'll wait and see what they propose.
All right.
I think this is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, excuse me, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving the court a heads up. I don't want to send you something and you would ask.
How about if I just say that is indirect evidence, sometimes called circumstantial? You don't have to do anything this weekend. I mean, not this weekend. It feels like that's the weekend. Then you don't have to do anything tonight. I'm going to suggest that, but you can do what you want. All right. Anything else on the instructions?
Not from the Commonwealth.
All right. I really didn't mean to set off a, well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this week and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Anna died of any natural causes. I read the pleadings that just came through. And if that is where the line is drawn, you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure or the allegations of reneging on a promise are impacted. But I'll qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. That's where I think the line is drawn by those cases. And knowing that's where I sort of am drawing the line, take a look at those cases and we'll discuss it again before the before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases, but what the court's saying is that you would think the Commonwealth could comment that something about
There is no evidence that Anna Walsh died of natural causes.
And of course, the defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
And I'm responding to something that the Commonwealth represented. I'm not going to go into right now. So let's just stick to this, if we may. So if the government's allowed to say what
I just said,
and of course the defendant can argue there's no evidence that there was any homicide or any.
Expect you're going to.
I shouldn't be here, I suppose. But I can once again recite the evidence of sudden unexpected death that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Anna Walsh. There's no testimony before this jury that ties sudden unexpected death to Anna Walsh, is there?
Judge, when the court asked me that, my response is the government's case is, using that phrase defense attorneys like to use, it's built on a house of cards suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game to argue because it's equally consistent. And citing the Eremos and Croft, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. There is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walsh. So why is it that the Commonwealth is allowed to ask the jury to speculate based on their circumstantial evidence? I shouldn't use the word speculate. Reach some conclusion based on nothing more than circumstantial when there's no direct evidence of a homicide. And we can't,
They can met out their burden with that circumstance. The law is clear there. They can met out their burden purely with circumstantial evidence. They can. And their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean from the searches to the other other distinctions in the evidence.
All of which, Judge, as we've always argued and we will continue to argue, came after any death. And so the issue is, what is the manner of death? And we now have evidence that from their own medical examiner, that death can occur suddenly, unexpectedly, without injury. And it's up for the jury to decide if they can. What evidence do they have as to manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. Atkinson testified to, and it's equally inconsistent with a homicide. All we're saying is they haven't They don't have any direct evidence of homicide. So why do they get to argue it based on their circumstantial evidence when their circumstantial evidence really might only speak to conduct post-death where the death was not a homicide? They haven't.
But there's evidence in the record before this jury that
I don't want to interrupt the thought process, but there was no objection whatsoever to the entire cross-examination of Dr. Atkinson. So all of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later, and so we made it.
so you could make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue. I presume that they are going to draw a line between some of the evidence that was retrieved from the bags as being circumstantial evidence of things that happened before the dismemberment.
I agree, it will.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. That's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Anna Walshe died of some natural causes, I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not created after a death. And so since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, and using the language and consciousness of guilt, a person is acting in a way not out of consciousness of guilt, but out of fear or fright or anything of the sort. So why isn't it that we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Anna Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the consciousness of guilt. And so the jury gets to decide. And it certainly, the thrust of that argument is that it raises a reasonable doubt. And that's the evidence the jury heard.
Your Honor?
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die.
Mhm.
The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but they're going to comment on the opening statement.
All right.
And that's why I was thinking we might find common ground here. I think
Sounds like
that-
we have.
Pardon?
Sounds like we have.
So as long as we're able to argue that a possible manner of death was sudden unexpected death, I understand that the government's going to stand up and say nonsense. And we're going to say homicide, nonsense. Have we found common ground?
I think we have.
I think we're close.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. Just be talking to one another
Thank you, Your Honor.
so that there's no surprises.
There's always.
That's true.
All right. And again, I did not mean to create a whirlwind of activity by my comments. I just think that the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen. But you have the cases now, all right? Take a look at the verdict slip. It looks very straightforward to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it. How long are the parties thinking they're going to need for closing arguments?
No more than 45 minutes.
All right.
That sounds good, Your Honor.
So 45 it is. I won't cut you off in a case like this, of course. I have cut off when it's a 2-day case and we're on 45, 47, but that isn't this case. And, but just, I know you'll all have a ton of experience, but 45 minutes is about as much as they can take effectively, in my view. So let's try to keep it to that. Well, we will be getting them fresh in the morning, which is good. As opposed to having, a couple hours of evidence in the bank and they're already tired. That's all I have on my agenda. Anything that you need?
Your Honor, would the parties have an opportunity to see the next draft of the court's instructions?
Yes. So I will be going back and editing as consistent with what we discussed. And I will then create a new draft and that will go out to you this afternoon.
Thank you.
And if I know that maybe there's some other language you want, I'll consider putting that in the morning. So maybe 8:45 tomorrow so that when the jury comes in, we don't have a big delay if we need to make any changes. And I think that's it. All right. Thank you. One other thing that I want to say is that you can be seated. I very much appreciate the work that you've done in the case to get the case in and tried efficiently on both sides. You picked what you needed to pick as your positions, and I appreciate the professionalism that you've shown on both sides in working with each other. And as I say, I drop into Norfolk County every once in a while as I drop into other counties. You and I, counsel, and I know that this is pretty much the routine of how the courts in the Commonwealth of Massachusetts operate day to day. There's nothing unusual about this case. The level at which you perform is the level at which I see when I travel county to county. And I appreciate the work that you've done on this case and will continue to do on this case.
Thank you.
Thank you.
Matters continue.
That was an interesting last comment. I don't know if you're here, Jen.
Yes, I did hear that. That was kind of interesting. There's been a lot interesting, though.
There has been a lot, yeah. Do you think that last comment was in any way a reflection on
Yes.
the other trials that we covered?
On Karen Reed. Absolutely. Absolutely. That was such a
Yeah.
backhanded little stab, I thought, that she made. Because there was no reason to say that, really.
Interesting. Yeah. So what else did you think today? Well, obviously we didn't. Oh, we haven't seen you since this morning, so we were all expecting. Oh, you might have a bad connection. I can't tell if you're talking.
Go
Can you hear me?
ahead. Go ahead. I'm almost to my router.
So you heard, unexpected this morning. We all expected that that he was going to testify, Brian, and he didn't testify, and they offered no witnesses at all. So were you shocked by that? I know.
Yes, and
I think
and
you
you
had
can
predicted
see
that he wouldn't testify, but yeah.
well, you can see the problem it caused. The problem is, and actually the Commonwealth is being quite kind, because
You're kind of in and out on the connection, Jen. And more, actually, you've been out now for about 10 seconds. I think you had said you were moving towards your router. So yeah, I haven't been able to hear you for about 20 seconds now. So sit tight, everybody. I'm sure Jen will just get closer to her router or go on to a different feed. So I thought the judge really showed herself very well this morning. Not that she hasn't showed up well during the trial, but her personality shone through in the last hour of discussing that. There was a lot of humor and definitely professionalism. So it was interesting to see. All right, let me see if I get Jen back.
that I don't know what happened.
I just brought you back in about 4 seconds ago.
Okay, great. I don't know if you heard me, but the problem with him not testifying, as is being pointed out quite clearly, is now they don't have any facts and evidence showing that she could have died from any other thing, that she could have died from an unexplained death, right? Except for they're trying to rely on the prosecution's witness that merely said, yeah, people can die of that.
Yeah.
But
Right.
to me, the judge is letting him off the hook a little bit. And so is the prosecution, saying, listen, basically you made that promise in your opening, but we're not going to exploit it. I found that very interesting. They're definitely not going for the dagger in this case.
Yeah, I mean,
maybe go ahead.
I was discussing this morning with Margaret that it seemed, she didn't think that it would be. Oh, thank you. Yes, I'll clear the screen. Thank you, Jane. She didn't think that it would be ethical for them to do something like that on purpose, but it works out certainly as a clever strategy where they introduce in the beginning the idea that Brian is going to say that she died in bed, and then now that jury still has that idea in their head, and it was reaffirmed a little bit by the state's witness, the medical examiner, that at least it's not impossible. But then that's it. Now Brian doesn't actually have to go up on the stand and say that happened, but at least that idea is planted. So it's kind of clever if that's the way if they did it that way on purpose.
Yeah, I think maybe they were going to wait and see how it went. And, they've decided that it went well enough, I guess, that they don't think they need to put him on. But it's really, look, it's a mistake to put him on, and it's a mistake not to, but maybe less of a mistake not to. Because like you said, they're going to be able to apparently lean on the few sentences that medical examiner stated about could be something, that people do die in their sleep.
Right.
So I just think the prosecution is very confident in their case at this point. So they don't seem to be wanting to, use any daggers, as I call it.
Right. And nobody wants to, because of the somewhat unique circumstances here, nobody wants to do anything that's going to ultimately end up being reversible on appeal later. So both the prosecution and the judge are being extra careful.
Right. They're being really careful. And I just think that they have it. And you just never know, though, what's really going to happen.
Right. We had a little bit of a discussion there about what the jury would be told. And so you get, this is like something that's always fascinated with me with this legal cases generally is, and we talked about it yesterday, and we've talked about it a little bit with Judge Garrett, the difference between speculation and inference. In the examples that you use, it can be somewhat obvious, but but in practicality, sometimes it's a very fine line as to where that is going to be drawn. So, by giving the jury, by showing that these potential weapons that Brian threw out, is that inference for the jury to conclude based on the fact that he was throwing them out in dumpsters, in public dumpsters, or is that speculation? It's, I don't know. It's just interesting.
I think it's inference. I mean, that's how I view it, because you just ask yourself, if your spouse, loved one, friend, somebody you didn't know died unexpectedly in your bed, why in the world would you decide to chop their body up and incinerate them?
Right.
And that's the problem that the defense has with all of this, along with a lot of other problems. And we talked about the knife too, with the blood on it. That's a problem. Some of those Google searches, Anna Walshe dead, and then, the later Google searches that mentioned murder. In other words, why wouldn't it be how to get rid of a body that died in its sleep?
Mhm.
You don't
Right.
see any Google searches that talk about what to do when somebody dies in their sleep. No, there's nothing along those lines. So there's nothing, as the judge well pointed out, to infer that she died in her sleep. Nothing.
Right.
Zero.
So each side has been given 45 minutes to make their closing arguments. They meet so the lawyers are going to meet with the judge tomorrow. So that we'll begin actually at 8:45. The court proceedings should begin as they finalize any issues regarding jury instructions. And so then they'll call the jury in, and then there'll be 45 minutes statement. There'll be 45 minutes of the defense, right? And then their closing arguments. Then there'll be a break, and then there'll be a 45 minutes for the prosecutions, and then we'll go into deliberation, right? So we should be in deliberation before lunch.
Oh, yeah. I mean, this is just going so fast and so smoothly. And I would predict we have likely a determination before the end of I don't know. I guess 45, that only gives them about 4 hours to deliberate. But I could see them coming in. No jury wants to spend the weekend and then come back on Monday. It's just experience talking. They will want to have it decided, but they might not, because, LWOP is significant, life without the possibility of parole. So they might decide this deserves more consideration than 4 hours. And then we've seen juries come back in 45 minutes on strong cases. So we'll see.
Yeah. I mean, I think there'll be some discussion in the room, but if it goes all day and you end up going into the weekend, that might be a bad sign for the prosecution, because if the discussion is that deep, then that might indicate that there's a juror that's holding out for whatever reason. So hopefully I think the prosecution is hoping for a decision tomorrow, and the defense is probably hoping for the opposite.
Absolutely. I do agree. The longer it goes, the more positive typically it is for the defense.
Right.
Quick decisions
Especially
typically are prosecution decisions.
And especially if you're thinking that the defense's best option here is a hung jury, so one holdout, which is, obviously if you're going to get an acquittal, you need unanimous decision on that. So that might take longer than a weekend too. A lot. So if they were going to arrive at a unanimous decision on acquittal, that probably would not take place tomorrow either.
Yeah, it's going to be interesting. I'm here for it. We're here for it. It'll be interesting to see what the jury comes back. I think a lot of people perhaps believe that they didn't really prove how Anna was killed, but the circumstantial evidence infers how she was killed, and it wasn't that she died in her sleep. And I really do think they made a mistake, probably not putting him on the stand, only for the reason that I think jurors will likely in this case hold that against him. They're not supposed to. It's not legal for them to.
Right.
But it doesn't
But
mean they
especially when
won't.
they were, especially when they were
Promise.
promised that by her own attorneys. So yeah,
Yeah, it makes them wonder what changed.
right.
You know, why all of a sudden, and as you said, and maybe you and Margaret pointed this out, was this just trickery by the defense to dangle that out there and then not do it? You know, so that they could get their point across. It's interesting. In other words, so basically the defense attorney could testify as to their belief on the case, but provide no evidence to support his position. And, you know, his statements are not supposed to be considered evidence, but will they in lieu of nothing?
Well, thank you very much, Jen. I've once again enjoyed covering a trial with you. Tomorrow, I'll probably be on for a couple of minutes early in the morning. Then I'll be gone to Boston. And we'll see how it goes. I should be home sometime around 1. And so maybe we won't have reached a verdict by then. But everybody that's watching, you can still find it on my channel as always. So you'll find it on all 3 of our channels. So Breaking the Case with Jen Coffenaffer, that's her channel. And you'll also find it on It's a Crime Media with Margaret McLean. And of course, Yellow Cottage Tales. Is there anything else you want to add before we get the afternoon off and you can go play some tennis maybe, or it's nice to
no, but just thank you. It's always a pleasure discussing these cases with you, Kevin. So I will see you tomorrow afternoon, it sounds like.
Thank you very much, Jen. We'll see you then.
All right. Bye, everyone.
And just the last word. So please remember Saturday at 4 p.m. I have a special interview of a scientist who's heads a team that is creates artificial intelligence software that is open. It's called open source software, so it's free for medical institutions and pharmacies even to pick up, and they use it to design drugs at the atomic level that would hopefully be able to help cure or help with major diseases such as cancer. And this is going to be the future of medicine increasingly. So this is a very important software. So I think a lot of you guys might find it interesting. So please, hopefully you can support that effort. And it's at an unusual time, Saturday at 4 p.m. And then I probably will go on at 8 o'clock to go over Anonymous Mass Lawyer's latest article. And a lot of people enjoyed the review last week of his previous article. So I haven't read it yet. It's always good. And so we may go over that Saturday at 8. So, and also on behalf of Jen, who just left, and Margaret, who is at the doctor's, thank you everybody for being here. And we look forward to seeing you all tomorrow.